Well, item one, I have no instruction permitted to refer if necessary.
All right. No instructions.
Item 1, my lord, in this case, my lord, we are appealing for the Union of India.
All right. All right. He's withdrawing, sir. He has no instruction.
Permitted to refer if necessary.
No, nothing, sir. This is a 30-year-old matter. All right.
We have challenged the notification.
Whatever.
If at all any action, they have taken action against us.
We don't give you permission, sir. That anyway you will take. You don't need anybody's permission to file a writ petition. He says no instructions.
My lord, Union of India, my lord.
All right. All right, sir. All right.
J. Naik CGC, my lord.
All right.
Okay. Special request item number 2.
May I please, Lord Lordship, in this matter, I have got instructions from the two persons has been.
So you have to speak louder. You have to speak into the mic.
My Lord. Your Lordship, I have prepared the dead chart. Your Lordship, handing over the same copy to Your Lordship. And substitution matter one pending. I pray next Monday.
No, we're not adjourning any matter, sir.
My Lord, substitution is there.
We'll do all that. You just first of all come to the matter now.
Yes.
My lord, in this case, I am appealing for the opposite party number. All the opposite parties in two matters. There are two. In the meantime, one opposite party or one to die.
Don't worry about all that, sir. Some life is not immortal for anyone. All right.
Well,
this is continuously going to happen.
If
this petition is pending, sir, for another 10 years, some more people will die. All right.
No, my lord. Next week,
No. I'm just saying we can keep on adjourning. There is no end to adjournment. But let us get to know what the case is about.
Yes.
Annexure, you'll on kindly see Annexure 567. That's a order passed by the Leonard.
Sir, in a short, in 2 sentences, can you tell us?
Yes,
sir, you can remove your mask if you do not mind. In 2 sentences, can you tell us what the case is about?
Case about I have got the land. Part of the land has been allowed in my favor, and the same has been the land which has been not allowed recorded in the land of government on Anavadi Khata. That thereafter Anavadi Khata that has been leased out by the Tahsildar in favor of private opposition.
Is this a 38B matter?
Yes, madam.
Yes. First of all, tell us that. Once you tell us it's 38B, many facts get explained.
38B.
It's a 38B matter. So what did the Tahsildar do?
Tahsildar allowed the lease in favor of the private opposition party without getting approval from the Board of Revenue, member Board of Revenue as per.
How are you concerned?
Because that land has been leased out in my favor by the headquarter and acted upon by the consolidated.
No, your claim Hattapata.
Yes, that has been acted upon by the consolidated husband. Partly.
The ex-intermediary recognized you as a tenant according to you.
Yes.
Did he open a tenant register?
Yes.
And your name figures in the tenant register?
Yes.
All right. Let's take us to the first, the Tahsildar's order.
That is your on file annexure 4. That is a 5 orders. Annexure 4 as at page 23. First order. Identical order, one case can be sufficed to the all. That is order dated 16/5/83.
Read it.
Extract of the order. The petitioners are the opposite party here. Sri so and so have applied for lease of land in respect to so and so. Istihar have been duly published in the village concerned Panchayat, but no objection received from any quarter. Istihar from the local Gram Panchayat there. OP have given consent on the body of the Istihar and the has no objection, and the petitioner is landless.
GP has given consent, government pleader.
Gram Panchayat.
1 minute. Mr. Parija, sorry. So the problem persists. We can't be subjected to this kind Yes.
Yes. Back to the land may be given to the petitioner. The case land was inquired by the Amin so. The petitioner have no land. The total income of so, and the petitioner in possession of the land. The reservation proceeding is not available in this office. The total Anabadi land available for the lease is 95 acre 34 decimal. The land is not reserved for any development purpose as it is agricultural land and cultivated by the petitioner. The petitioner are landless per Harijan and no landed property except homestead land. As per the government instruction, the petitioner are entitled to get 1 standard acre of land, but the petitioner are in possession of 60 decimal of land. Hence, in view of the above following lands, settlement of the favor of the petitioner with 20 decimal of land, each RI to collect rent and from 83 to 84. And Amir to press so order pronounced. In that proceeding, I am not a party, and also there is no objection from her, and the GP has a consent, as you also pointed out. That order, there are 5 identical order in favor of the opposite party. That order challenged before the ADM. That ADM is annexer, the Lordship will find appellate order. That is at page 38, annexer 5. Annexer 5, that is laying the order. And what has been, may I permitted to place out the paragraph of page 2, internal page 2, 39 page.
Yes.
The case of the appellant is that the plot number, that is the disputed plot, which is 25 so and so, where in the expert of the intermediary Bhagavat Prasad Bahanti and others, which vested in the government office so, and the after provision of the Orissa State Abolition, the father of the appellant was inducted as a expedited and inspector so, and tenant in the year 1944. Since then, he by reclaiming the said land, he had been continuing tenant under the interpreter till death and vesting of the case. Then thereafter, after death of the father of the appellant, he has been possessing the self land as a tenant thereafter on behalf of the family. It is stated that appellant father was paying rent expended and after vesting this Tahsildar. It is also stated that the appellant's father were the settled royal of the village. As such, he had acquired right of occupancy over the aforesaid land as per the provision of the Orissa Tenants Act. It is further stated that appellant have their so and so village Goda Ita Pukuri, which was Gochar land. There was no sufficient Gochar land in the Sud land. It is further said that due to non-available sufficient Gochar land.
No, all these are your submissions. Let us go to the discussion, sir.
Yes. Then sort out the matter from the impugned order that is passed by the learned member board. The learned member board observed.
No, 1 minute, sir.
Sir.
There are findings here. Please come to that page 44.
Yes. Yes, 44. 44 is issue number 1. It is urged of the respondent that the instant appeal is barred by limitation, which has been also allowed.
All right. Issue number 2. Now come to issue number 2.
Issue number 2.
Page 46.
Page 46. On the it is on the appreciation of the claim.
So even that is in your favor.
I am in. Yes.
Now come to issue number 3, page 47.
That is regarding plot number. Father is also is a tenants in their accepted. The only.
No, one come to page 47, sir. Issue number 3.
47. Yes. Regarding the plot number, the father was in so and so. Reclaiming so and so, say the repeated facts. The appellant father was inducted tenant under the extraordinary, and the last person of the the stance has been challenged by the learned advocate of the respondent to that in 1927 settlement record dispute proposed where partial part and parcel of the estate of the Satyaprem Mahanti and not that Bhagavat Mahanti. It is stated that. And the second paragraph, subsequent paragraph 49, regarding some interpolation, it is alleged against me, that is Satyapra Mahanti and Bhagavat Prasad, they are co-share. And your lordship find from the page number relevant is, as your lordship pointed out, section page 50. There is a find.
No, I think you read page 49 onwards, sir. peruse the records. Please read it carefully and slowly.
Yes. Peruse the case record filed on behalf of both parties. Unregistered quota has been filed on behalf of the appellant showing that one Bhagavat Prasad Mahanti has leased out so and so in favor of the appellant's father. In the alleged quota, plot number so and so have been interpreted,
Incorporated.
but incorporated. But I find there is some interpolation in the area of the case land, since there is an unregistered document and has not been duly proved. I am not inclined to so and so. Further,
What is so and so? Why are you in a hurry?
No, sir.
The most
sir.
crucial line is so and so and so and so.
So that's why I am saying that on 7th, I can precisely say.
No. The same line will not change on the 7th. You still have to read the same line on the 7th.
That is, yes, I am comfortable, I can say.
Since this is an unregistered document,
has not been duly proved,
I
am not inclined to place reliance on this document. Further, no evidence was available on behalf of the appellant to substantiate the contention that he was actually inducted as a tenant by the ex-intermediary before the vesting. If actually they were occupancy tenants by the intermediary before the vesting, it was actually their occupancy tenant under the Jamidar. Their names should have been mentioned in Jamabandi submitted by the ex-intermediary to the Tahsildar after vesting. Also, I find there is no display of opening of tenants register.
What I asked you, the first question was this.
Yes,
and you kept saying yes to everything.
Yes, the annexure 1, 2 series.
No, we'll come to that. You read this now first.
Yes, sir. I filed that. I know my limitation. I know, since there is no entry into the tenant's ledger in favor of the appellant father, the appellant, and since no evidence was filed indicating submission of the Jamamandi by the Tahsildar expedient in favor of the appellant in respect to the property, I am unable to appreciate the contention of the appellant that he was actually inducted as a tenant under the expedient before vesting of the question. Further, there is no document made available by the appellant to indicate that rent has been paid to the expedient right from the so-and-so year of 1944 to 58, and the Tahsildar from the year 1958 to 83, except 1, 2, which are eligible. Further, perusal of the certificate of the report of the RI Brahmakundi in objection case number 3 to 5 so-and-so before the assistant consolidation officer Hodar leads to me believe that the claim of the appellant over plot number is ill-based. Further, the certified copy of the Khewat number reveals that one Satyapriya Mahanti has got 1/3 interest over the 1000 numbers including. It is also noticed that plot number comprised of area so and so. Plot number 2590 is this case land comprising of 81 decibel. Since Satyapriya Mahanti is entitled to 27 decibel out of plot number 2306, 27 decibel out of plot number 2590. But unfortunately, it is found that the alleged unregistered quota alleged to have been executed by Bhagavat Prasad Mahan, that 80 decibel out of plot number 2306 and relevant plot have been leased out. This stand is not believable that the ex-Jamidar who has got 1/3 share has leased out almost the entire area, entire land in favor of the appellant. After all, shared and done, the facts remain that the alleged unregistered quota has been proved duly. The factum of payment of rent is to the ex-intermediary and Tahsildar has not been proved beyond doubt. No Jamabandi has been filed in favor of the appellant. No tenant ledger has been opened in favor of the appellant. Therefore, I do not find any possible reason to accept the contention of the appellant that his father was actually inducted as a tenant in respect of plot number 2306 and 2590. That is case land. Admittedly, in 1920.
So now tell us what is wrong with this order. Okay, you went to the member board of revenue and he's affirmed this order, correct?
Yes, affirmed order on the 2 points.
So tell us what is wrong with this order now.
Let us have a glance. 2 paragraphs only.
All right.
That your lordship kindly come to the page number running page 70.
Right.
That is in order of the
Member Board of Revenue.
Yes,
All right.
yes.
All right.
That begins from the last paragraph. Plot number so and so, page 70, or you got it?
Yes, yes.
70. Last, I want to take not much of time. And second, recorded Onavadi Khata number, that is the case land, 954, plot number, half plot number 3890. That is the case land. Only one plot. Two plots in this above. The petitioner has come up some revision additional research, revision method, and leaves out by the OP in the 5 revision case numbers, and claiming that right, the last paragraph 6 is relevant. From the above recital, fact, it is clear that petitioner claimed that he is a tenant in respect of plot number out of so and so, consolidation khata number proceeding plot number recorded in his name. He is rare, therefore he is confined to plot number 2590, in respect of which he claims tenancy created in favor of the father. Out of the plot number overriding 60 decimal, which has been leased out to the opposite party in the 5 lease cases referred to earlier. His appeal and revision has been rejected, and he has come up under 38B of the Act, under section 38B of the Act only, in order to pass under order. Under the Act can be revised by the Board of Revenue. Here the lease in the 5 lease case have been given out. Savik plot number so and so, Orissa Government Land Settlement Act. These orders of the settlement have been challenged by the petitioner in appeal and revision. All those are orders under Orissa Government Land Settlement Act. The revision order of the land additional disease by state under the Act cannot be challenged in a proceeding under section 38B. The petitioner also say that the OPU have been leased out 30 decimals in the land case plot number 8. According to his own case, he was not a tenant in respect of the food plot and plot numbers 1689, also not included in the area of 2 acres 74 decimals, in respect to which the claim of tenancy was created in the name of his father by the extraordinary. Therefore, whatever may be the validity or otherwise settlement under plot number 1689 of we in this 5 revision, that has not been taken into its claim of the tenants. He further claims that the plot number 2590, which is his royalty land, have been recorded as Anavadi Khata during the consolidation operation. If he is not satisfied with that recording, he has to challenge.
What is wrong with the order, sir? Tell us.
We'll
go back to the ADM's order itself. The member Board of Revenue says, I can't deal with this under the Estate Abolition Act. You have to go under the Settlement of Lands Act, because you have to challenge the consolidation of holdings. It's a different subject matter. I cannot deal with it. So as a jurisdictional issue, is refused to entertain the revision petitions. What is wrong with the ADM's order? You tell us that.
Even if we'll go to the order of the Tahsildar and
So
ADM.
on facts,
No.
on merits, what document do you have
on the
to
basis,
show that
on the basis of
your father was a
and
tenant?
On the basis of materials under Annex 5 and 4 and 5 impugned order. That is order passed under OGLS Act. If the order is found to be genuine, it has to be got concurrence of the Board of Revenue, members Board of Revenue, by order section 4 of the Board of Revenue Act. Because in view of the Harapriya Vishwa case and Gundam Sharma case, and also Lordship passed recently an order in the Bidanesi case, which I want to produce.
No, all that you produce, but you tell us on facts. What document you have? What document do you have to show your father was a tenant?
Annexure 1.
What is Annexure 1? Come to Annexure 1.
Annexure 1 is Jamamandi.
This has not been believed, sir. There were interpolations. There were interpolations. We are not a court of fact here.
No, I do not say so. I do not say. I also not.
We are only on 226, 227.
Once a GP has given the consent, and the Tahsildar is not produced.
No. So that is why it was challenged before the ADM.
No, that is your lordship.
The ADM called for the record. He found interpolations.
No record corporate. Record corporate means trial court record, which has been lease record.
All right.
The Tahsildar has not called for the tenant ledger.
All right. There is no tenant ledger. You are not able to produce any tenant ledger.
Tenant ledger is within the Tahsildar. I have given the certificate of Annexure 1 series.
Right.
Annexure 1 series, my Dharmu Patra name is recorded.
There are interpolations.
I do not want to repeat that sentence. Once a GP has given the consent for the purpose of
it can't go by that consent, sir. what is in the document is in the document.
Had this been recorded, produced before the ADM and the member board of review, I would have been get the claim. Once it has been accepted by the consolidation. I beg pardon, my lord.
Yes.
Consolidation authority accepted the lease quota.
All right.
Partly and refuse another part. And another part refuse on the reason that Section 5 Board of Review Act is barred to settle the land. Because once a lease has been granted by the favor of the party, it has to be given concurrence by the Board of Revenue member as per the Section 5 of the Board of Review Act, and that is the point of law. That's why matter should be set aside and remitted to back in accordance with the law. I do not say that land will be given to me, and that once a consolidation authority has been acted upon partly and denied to the authority, once a order has been passed by the consolidation authority without OGL settlement cannot be. And two citations are there, Harapura Bishoy case and Vrindavan Sharma case is squarely covered to me. And now another part is, once a lease has been granted by the wrong or right by the authority without setting aside or without any order by the authority, the consolidation cannot entertain my claim to record or to file a revision under Section 3738. That is the impediment myself. And another fact is, another legal aspect is, once a matter considered to the extent which your lordship pointed out, I have in out of zone of consideration. Always. And the Board of Revenue member said, you go to the consolidation authority, shifting of burden. He is the master of the authority, master of the state in the record of the revenue authority. And it is a duty burden under him to examine the matter. He had been also so much of power under Section 13. Please produce all the records. Whatever the record, the LCR only available in the lease record and the ADM and the revenue. My contention is that. Yes, I do not want to say that my record, your lordship passed me order in my favor. That has to be in my favor because I have not given opportunity of hearing before the Tahsildar. And also that is step by step against me.
It is your appeal before the ADM, sir. Your revision before the member of Board of Revenue. How much more you want to be heard?
Yes.
Even here we are hearing you.
Once
this is the third time you are being heard.
Once they have not taken into
consideration.
consideration.
Some court you should show some document. You are not able to show a single document.
Your lordship, a ODA document, and your lordship, I pray your lordship, brother Justice, to see. My father's name is there in the tenancy letter.
All right. Yes,
my
Mr.
father's
Monte.
name is there in the tenancy letter.
Yes,
Dharmapatra.
All right. All right.
No, it is a rival claim between two private persons, but my respectful submission is that he is mainly relying upon that tenant's ledger, Annexure 1 series, which according to the finding of the learned court below, that it is interpolated.
Correct.
And the basis of the claim is the genesis of his case is a Hattapata, which your lordship knows how the Hattapatas are being made. And the subsequent tenant ledger, that is also a product of fraud. What is the finding of the learned court bill? So that is factually he has no case.
This is the difficulty.
Relying upon the Hattapata, consult. Acted upon.
All right.
The evidence is produced before. The only one plot has been reduced to illegally recorded in the name of state.
Right.
In the meantime, the lease has been come up.
Yes.
I want to challenge that lease on the following grounds.
Right.
After the lease, even if I have no Hattapata interpolated, the document and ledger is with the authority.
Right.
That has not compared. The authority once GP said so, who will say no? And in that proceeding, I also not a party. Contribute this. And the appellate authority, revisional authority, there is no scope to give evidence, oral evidence. How can I suffice? The matter should be remitted back to the Tahsildar for fresh hearing, giving opportunity to the party. And substitution matter, if any, be there. My humble submission with folded hand and humble submission that matter should be raised before the Tahsildar by all the parties concerned and the matter should be decided afresh so that proceeding can be go on ahead.
All right.
That's my obligation. And one substitution matter may kindly be allowed by IS 60.
Yes, sir.
All right. The petitions are dismissed. We'll pass the detailed order. All right. Yes.
Special weekly list item number 3.
My lord, that first item I am not pressing it because it becomes introductory.
Dhruba versus state, you say counsel for petition is not pressing the petition. Dismiss
The second sub-item, my lordship, I am appearing there. It is also become infructuous, your lordship.
All right. Mr. Biswal states this petition has also been rendered infructuous. Is disposed of as such.
Special utilist item number 4.
Well, item number 3, I'm for the opposite parties.
All right, sir. All right.
Okay, sir.
Item 4.
None appears dismissed for non-person.
Special weekly item number 5.
This is the case, my lord, regarding a tank.
Sorry?
Tank in the midst of the village, which is the villagers were fighting from the year 1955 for the settlement in that land in the name of the government. And the ex-intermediary, I have a death chart.
Keep this with other matter. The matter is still pending before the Tahsildar.
No, my lord. This matter was that last order, my lord, can be seen in 6/12/2019.
6/12?
2019. This court had the matter and directed to produce all the record of the annexure A/2. And the main ground is that this land was not tested by the authority, collector, and the Board of Revenue under the established state application of under section 5(1). And the villager was the right of the tank, was not the party to the proceeding. Whether they have record with state. And interestingly, they deemed that property was, though the Board of Revenue hold that there is no tank is involved, they stated that they deemed that the tank was involved. And it is a communal tank, and the by a hukumnama that Jamidar was give, and after the cut-off date 1st January 1946, this clearly stated annexure that it was given in 1st July of 1950.
Yes, please.
Whether the government has that record to produce, and that
you tell us what is wrong with the impugned order.
That impugned order,
you first read the impugned order, sir.
May I place my
yes, please read.
No, the impugned order is that prior is the passing of the order of the annexure 2 and the confirmation order by the annexure 3 to the Board of Revenue under the State Abolition Act. The State Abolition Act.
So why don't you read the order of the sub-collector?
Yes, ma'am.
This appeal is your appeal, correct?
Yes.
It was your appeal before the sub-collector. Please come to page 14.
Yes, it is my appeal. The villagers. And state also filed appeal.
Sir, I asked you a question. Can you answer the question, please?
Yes, ma'am.
Page 14.
Yes, ma'am.
Please turn to page 14, sir.
This is the order of the...
Is it in your appeal?
Yes, ma'am.
Please read the order, sir.
This proceeding under the 5.0 Act was initiated on the strength of the report of the Tahsildar Baleswar, the Manoranjan Jena and Niranjan Jena are the respondents. The following land schedule is given. That the brief history of the case that Khata number 106 is original recorded in favor of Manmonath Dev and other on Khata number 1, the Jamidar effected the unregistered pata in favor of Kamal Lochan Jena, son of late Madan Mohan Jena. The village Karakul inspect the case land. Similarly, another pata. This same Jamidar was issued two pata. One was in the name of the Kamal Lochan Jena.
Say you please read on, sir. Kindly read on without stopping.
Similarly, another pata was also granted to the Birabhadra Bari by the same Jamidar in respect of area of 1 acre 73 decimal out of pata plot number 91 of Khata number 26, the same village. When the villagers came to know about these two leads, they submitted a petition before the Anchal Adhikari, Baleswar, praying the start proceeding under section 5(1) of the Orissa State Appellation Act to nullify the lease. The Anchal Adhikari Baleswar submitted a report to the Deputy Collector Baleswar, who initiated case number 49 of 55-56 under section 5(1) of the OE Act, as there is no clarity. As there is no clarity of the land schedule involved in this proceeding and no direct record is available in the initiation of the proceeding for plot number 91, Khata number 26 and plot number 354, Khata number 106, a series of case and counter case have been filed to different forum. State Arbitration Appeal number 9 of 556 before the Board of Revenue, miscase number 3 of 79 before the SDO Baleswar, miscase number 68 to 79 under section 144 CRPC before the SDM Baleswar, OJC 10382 before this Honorable High Court. We have the view of many. How the Honorable High Court in OJC 10382 observed that the revenue miscase number 3 of 79 started by the SDO Baleswar in just and conformity with law. Simultaneously, the Honorable Appeals Court has also given scope to the petitioner. The opinion number in this case, the ventilate their grievance and prove if a previous proceeding under section 5(1) of the OE Act for the plot number 354 classified as Gadia. Gadia means tank. In Khata number 106 village, Korkor was initiated and dropped. It has also been observed that if it is proved the miscase number 49, 55, which covered plot number 354, Khata number 106, the village of village Korkul and second proceeding under section 5(1) OE Act obviously not lie under the background of OE case number 52 of 81 has been initiated. Had the AGP on behalf of the state and the learned advocate for the OPs, learned AGP appearing on behalf of the state contend that the OPs Srimati Basanti Jena and others have a good case for reasons stated in the written argument. Plot number 354 area 1035 decimal of Khata number was actually covered under the miscase number 49, probably 55 or 56, as is evident from the order dated 24/12/55, in the which everything has been elaborated in support of plot number 354 and nothing has been reflected.
Just come to page 22, sir. Internal page 9. Page 22, internal page 9. Even though in the final order, read
Yes,
that paragraph.
If though the final order, this appeal number 9 of 56, the tank in question was not mentioned. The tank is not mentioned in the appeal number 9 of 56. It is deemed that the appellate court did not lie to interfere with the decision of the lower court with regard to the tank. Hence, the all intention adopt and purpose, it is taken and granted, it is taken for granted that the order of the lower court been confirmed, though the final order simply deals with the other plot number 91. The all along plot
Read on, read on, sir.
by dismissing the appeal, first 1/5/1956, the order of the lower court has been confirmed.
Read on, sir. Please read on.
So it is clearly established that plot number 34 of area 35 decimal of Khata number 1 village was covered under the 5-1 proceeding previously, in which villagers and the teacher OPs were parties. Thus, first issue is answered the full benefit of the OPs.
Read on. As regards possession.
Position, it is crystal clear from the Omni report dated 22/7/78, tagged in miscase number 58/78 in the file of the Tahsildar Barasur, that the OPs Kamal Lochan Jena and others are possessing the plot 354 with the TL open in their favor. Since the date of transfer is 5/7/1950. Date is mentioned that transfer is 5/7/1950 after the cut-off date 1st January 1946. As per the State Tabulation Act, 46 is the 1st January 46 is the cut-off date. Another important point which will merit consideration that petitioner of the Tauji, it is clearly mentioned that at para 7 order dated 30th October 81, in miscase number 3 option that the Tauji was partition and the after partition, the kisam of the plot number 2 was changed from Podia to Gadia. The position of the land is that the time of partition, the Tauji, if any Jamidar makes any applicable improvement of any tank by being the exclusive possession of it, concerned property is assessed to rent and such property will not vest in the government and it is to be deemed to tenanted land. So the ex-intendant had every right to transfer it by way of lease, which cannot be questioned.
So the other side has been in possession since 1950.
Other side was that may press the annexure 5 of Regender. That is the first report of the Anchal Adhikari. Who is verified the document? No one verified the Hukumnama. It is a Hukumnama in the order, not a lease. It is a Hukumnama. It's clearly stated
So
that
there is no stay granted by this court.
yes, stay is granted by this court.
When? Only further proceeding has been stayed, sir. Only further proceeding has been stayed.
Yes, madam.
There's no status quo granted by this court.
Madam, this court was pleased to stay the proceeding for the.
So there is a difference. There is a difference between stay.
This order was.
Sir, will you, with your kind permission, can I complete my sentence?
Yes, ma'am.
There is a difference between stay of proceedings in a court and status quo being granted. There are two different things. Do you appreciate that?
Yes, ma'am.
So here there's only a stay of further proceeding, not status quo.
Yes, ma'am.
Even if the court had said status quo, it will not help you since the other side has been in possession since 1950.
Yes.
So how many years have they been in possession, sir?
My humble submission is.
You don't want to answer. All right.
The authority that the opposite party number, private opposite number 2 and 3, the land was recorded initially in the name of the government. The settlement authority, may I place my date chart, my lord? It will be very clarified, my lord.
Don't start from the beginning. After reading so much, don't start date chart from 1950. We have already seen all these facts in what you have read so far.
My lord, kindly, that document, which was the report of the Anchal Adhikari, that is the very first investigation by the Anchal Adhikari after the villagers was. That is very important, my lord. Annexure 5 at page 81.
Yes.
My region.
Yes.
Miscase number 49 of 1955-56. The first investigation report by the Anchal Adhikari, page 81. May I please, ma'am? This case number 49 of 1955-56. Subject: fraudulent lease of plot number 91 Nichosas land. The villager of Korkul under Union 4 Baleswar then filed two petitions. They filed two petitions and the lease was the two lease. One is plot number 91 and second is plot number 345. Plot number 91, I read that. They filed two petitions. Along with that, Nijosas plot number 91 with area 1 acre 73 decimal under Khata number 106. Our village is a mango grove out of which small portion is used for the school and they remain for communal purpose, such as Dolojatra village meeting and etc. They have also stated this can be used for the Grama Panchayat building. The complaint that one Birabhadra Barik of the village stating he took lease of the plot, fenced it and in December 53 with the help of his well-wisher and consent tree, they say that the lease if any may be cancelled and the plot be declared communal one. On being summoned, Birabhadra Barik has filed one Amalanama and two rent receipt of 1 acre 60 decimal of this plot, stating that the Jamidar could not watch the Grove and gave it is with him. Though Amalnama Pata, I visited the plot and this recorded the statement of Birabhadra Barik, Bhanja Panda and Sundar Mohan Jena. I have also done a rough sketch of the plot with adjusting plot, the Amalanama Pata and the receipt. After that have been written in with new ink in old paper. It came to then these two and Bhanja Panda fenced the plot. It therefore after that is Jamidar selected the Birabhadra Barik for this Amalnama instead of Padmalochan for fear that the Amalnama would be suspected if the Amalnama is granted in the name of Chatia. The conditions under which the Amalnama is granted are peculiar. The Amalnama for this house of a house to watch the crops raised in the plot and the mango yard. It also states that the proper salami was recovered and there is not even any scrap of paper in support of this. It is definitely stipulated that the lease should be pay rent only after making it land fit for cultivation. But the lessee admit it has a statement that he could not raise any cultivation in it, even since the Amalnama was granted due to his continuous absence of Nilgiri, Baleswar, and Pantapada and Rupsa on account of his service in the railway. Yet he produced two rent received only for 1352 1353 and 1355 Sal. That is converted 1944, 1945, and 1946 as per the English.
All right. Yes, Mr. Monty. Yeah, Mr. Das.
Lord, here the private opposite parties first approached this honorable court in the year 1982.
Right.
Assailing the initiation of subsequent proceeding under OA Act.
Right.
Now this honorable court disposed of the writ petition, saying that if you have material showing that this particular patch of land was already involved in the previous OA proceeding, then the subsequent proceeding will be dropped.
Right.
That order is at page 12. This honorable High Court's order.
Right.
May I need to read read the portion of that order?
Yes, please.
Lord,
Mr. There is nothing in the order from which it can be concluded.
Yes, my lord. Now, my lord, that is under Annexure 1, the High Court order, my lord.
Right.
Page 12 and 13.
Yes.
And then subsequently, the sub-collector in that OA appeal case number 52 of 81, both the parties were allowed to adduce the evidences, documentary proof, and the petitioner in the instant case was the appellant there. He could not cite any document. Rather, the collector, sub-collector on its own and after perusing the order sheets of the previous OEA proceeding, that is of the year 52 and 53, came to a definite conclusion that this particular patch of land was already
part of that
proceedings, my lord.
And it had been decided in favor of the opposite party.
Yes.
Yes. And that has now been affirmed by the Board of Revenue.
Yes. So therefore, my lord, since the same land has already been was a part of OA proceeding, so subsequent OA proceeding for the same sort of land cannot be
maintained.
Yes. So on that score, my lord, moreover, it's a PIL, I think, my lord. So it's not that any private person are interested to have.
Right.
So,
yes, sir.
My lord, kindly that High Court order 103 of
yes, yes.
82.
Yes, yes.
Para 2 mile.
Yes.
That it is no dispute with the aforesaid preposition of law, but the only question for our consideration is whether the earlier proceeding was really with regard to the tank in question standing on the plot number 354 appertaining to holding 106 or not. The subdivision officer judgment ordered under section 5.1 of the Act clearly came to the conclusion that there is no material before him to consider that the earlier 5.1% was really in respect of the tank in question. That in view of the matter, it has been directed to the initiation of proceeding of the 5.1 Act. The state was initiated 5.1 proceeding, and that 5.1 proceeding, challenging that 5.1 proceeding, they came to the High Court for this order.
So that has been upheld. That view of the matter. Come to bottom of page 12.
Yes, ma'am. That page 3, my lord, last line. We do not find, and the court has observed that we do not find any information in the order of the subdivision officer directing initiation of 5.1 proceeding in respect of the tank in question. Needless to mention that in open to petitioner to establish the appropriate revenue authority to that the earlier proceeding was really in respect of the very tank in
so
question.
Now on it being remanded by this court,
yes, ma'am.
They have found factually that it is covered. The earlier proceeding covers the tank as well.
No, my lord. The earlier proceeding was only against the
that went against you, sir.
Yes, my lord. They are document, my lord. They are
no. You have to show why the order holding to the contrary is wrong.
Yes, my lord. In order of the annexure A by 2, they are counter, my lord. My lord, this court was hold that only Birobhadra Barik was the party,
right?
Not Kamal Lochan Panda anywhere.
Right.
And the plot number 34 was not mentioned in the any lower court order. And the area was 35 decimal not mentioned. Only area of 137 was 173 was mentioned.
All right. The petition is dismissed. We'll pass the detailed orders. All right.
Special utility list item number 6. Item number 6.
The state of Orissa time to time announces package of incentives for rapid industrialization in the state to the entrepreneurs for small, medium and large scale units. I have given a compilation of all the industrial policy resolutions. There you also will find that from 86, I'll only place 86, page 80 of the compilation, clause number 7.1.5 of 89 IPR.
Yes.
There, you also will find that all small, medium and large scale industries have been given this benefit.
Right.
Then your lordship will kindly see of page 164, clause 7, 7.1, 7.4 of 92 IPR.
Sir, page 164 is some alphabetical index.
Oh, my lords.
What you have given us is this, sir.
Yes, yes.
Another one is there, big one.
Big one, my
The
lords.
IPR, all IPRs. are there.
All compilation of IPR is given.
This much of volume.
This volume. So sorry, my lords, the red chart, because after the industrial policy resolutions is passed by the state of Orissa with the approval of the cabinet, my lords, corresponding notifications are given in exercise of power under section 6 of the OST Act, so that the benefits can be availed by the entrepreneurs. Then, my lords, we are concerned with 96 IPR. That part 2, Lordship will be pleased to see 225. Lordship may be pleased to see clause 2.1. It starts part 2.
Yes. Effective date.
Yes, effective date. Then, my lords, the clause number 5.3, 5.3 says cell tax incentives under this policy will be available to all new khadi, village, cottage and handicraft industries and new small, medium and large industrial units, and expansion, modernization, diversification of industrial units after the effective date.
Yes.
Then your lordship will kindly see clause 5.6. All new, small, medium and large scale industrial units will be eligible for exemption / deferment of sales tax on purchase of machineries, spare parts, raw materials, packing materials, final finished products, or in the manner indicated below.
What is in your case, what is the effective date?
Effective date is 1/3/96.
Okay. And when were you set up?
Yes, it was set up. Lordship will kindly see the certificate given under Annexure 1 at page 18. I set up the industrial unit as a small scale industrial unit.
Yes.
Then I upgraded it to a medium scale unit and got the certificate of the Director of Industries.
So same point. So you can't sit in appeal over the DIC certificate. We have held in earlier cases.
Beg your pardon, my lord?
In the earlier cases, we have held. This is not that.
That is not that.
These are not that. Not that. Please allow me to speak. Mr. Sir, you are, please.
My lord is asking so that I will reply.
What is the dispute here, sir?
Beg your pardon, my lord?
What is the dispute here?
I am yet to find out.
What does that mean?
Dispute is...
Why are you here in court?
Yes. My lord, what he does, he doesn't allow me to speak. That
No. You're too senior a lawyer for him to stop you from speaking, sir.
Sorry. I'm extremely sorry to understand the question, my lord. Then your lordship, I will take your lordship.
No. What is the dispute? I really want to know.
Dispute is, my lords, once I have been upgraded and got the certificate as a medium scale unit,
right?
Then I am entitled to avail the incentives as a medium scale unit under IPR 96.
Right.
Therefore, I have given the red chart.
No. So why are they denying you that?
Yes, lordship will kindly see the counter affidavit as they have filed. That is by the state at page 56.
Yes.
For a minute, my lordship may kindly see.
Yes.
56.
Yes.
They don't deny, my lords. I am placing, my lords, that in reply to para 1 of the writ petition, it is submitted that the petitioner's unit originally was a SSI unit. This was the counter affidavit filed by the Industries Department.
Yes.
And accordingly, PMT registration certificate was issued by the GM DIC Keunjhar, bearing registration number so and so 15/8/19 01788. Lordship may kindly excuse me, I have got developed the cataract, so I am not able to see it properly. So,
You want to ask your colleague to read?
Yes. Dated.
No, you can ask your colleague to read, sir. No difficulty.
Yes.
Para 3, my lord.
Yes.
That in reply to the paragraph 1 of the writ petition, it is submitted that the petitioner's unit originally was a small scale industrial unit, and accordingly PMT registration certificate was issued by the general
No,
manager.
but we've read the whole paragraph. This registration certificate was cancelled by the DIC.
And was substituted by the DI certificate, and I got the license from the government of India, my lords.
Right.
It is not disputed by neither by the industries department nor by the finance department. Now, my lords, it is also not disputed that being I have acted on the promise of the resolution contained
So the DIC is still supporting you.
Yes.
This is the DIC's affidavit. They say you are still an
Yes,
industry.
that is the industries department is supporting me.
So the tax department is opposing you.
The tax department partly also says that I am an unit of 96 as a medium unit. They also para C. Lordship may kindly see the page 72.
Page 72, para C, my lord.
Yes.
They also say that I am a medium unit.
What is EMD portion?
EMD is expansion, modernization, and diversification. What has been done, my lords? It has been very loosely used. It is actually upgraded. Lordship just now have seen that once.
So they are stand in para C.
Para C.
They say you
They
can
say that
you can get it only once.
Yes, they say that after, because of the clause 5.7 of the IPR 596.
So they say once you get it as a SSI unit, you can again get it as a medium scale unit.
That is the case, man. And my contention, and also that has been also DIC has also said that Lordship may be pleased to see 66.
Yes.
Para B.
Yes.
Para B. Lordship may see the finance department counter affidavit.
Yes.
That on 23/3/1999, the general manager DIC Keunzar also granted an eligibility certificate to the petitioner in the separation to the person or to the earlier certificate issued by memo number 141 dated 8/1/1999, certifying that the unit is a new small scale industrial unit having commenced its fixed capital investment on or after 1/3/96 and starting commercial production with effect from 10/12/98. Since the fixed capital investment was made after the effective date, that is 1/3/96.
No. So what is your answer that you can get it twice?
No.
Once you can get it as SSI, then you upgrade, you again get it as a medium scale. This is your contention.
So far as Lordship will kindly see, there is no denial to the fact, my lords, I have been upgraded to a medium scale unit.
So what you need is incentive. No, 1 minute. You need incentive to grow. In fact, with the incentive you got as SSI, you grew to a medium scale.
Yes.
What more incentive do you need now?
Because, my lords, medium scale unit, the production, the incentives which I have availed so far as the small scale industrial unit when I was, now the production has increased. Now they have to reduce what sort of the overall production as a medium scale unit and give me the benefit, because I have opted for a medium scale unit after establishing 3 more kiln. 3 more killing in that part cannot be brushed aside. I have got, there's no denial of the fact, and I have received the benefits. What I say, my lords, lordship may kindly appreciate it. It is a fact that I have acted on the promise made by the state government. Now the question is, they say that after, that is their case, that after I have gone expansion, modernization, diversification, only the existing units
Right.
my lords. Can I resume, my lords?
No, we'll just ask him the question.
Yes.
Is there any prohibition on an industry which starts off as an SSI, avails incentive, while the policy is on, fulfills all the requirement for incentives for a medium scale? Is there a prohibition? What you have now started in your para C, you say it's impermissible for a person to get it twice.
Your Lordship, within 2 minutes, Your Lordship, I may be permitted to convince Your Lordship. Your Lordship, there are 2 provisions. Your Lordship, 5.6, para 5.6 and IPR 96, para 5.6 and 5.7. So as per 5.6, Your Lordship may kindly turn to 5.6 230, page 230 of that
compilation.
The compilation. Your Lordship, at 5.6, all new small,
correct,
medium, large scale industrial unit will be eligible for exemption. Your Lordship, let me. Pursuant to this 5.6, the petitioner is availing exemption as a new industrial unit.
No, let's see.
I'll go to that. I have understood your question. Your Lordship's question I have understood. Right. Only 1 minute, Your Lordship.
Right.
Your Lordship, on dated 1st March 96, this exemption IPR 96 came.
Right.
3rd May 96, his capital investment has been started as a new industrial unit.
Right.
10/12/98, commercial production has been started.
Right.
DIC has issued the certificate on 8th January 99 as a new industrial unit.
Right.
Your Lordship, then Your Lordship, he has availed the exemption from 18/12/98 to 9/12/2004.
Right.
Now, Your Lordship may kindly turn to section clause 5.7. Your Lordship's question.
Right.
Your Lordship's question is that how the 5.7 says that expansion, modernization, diversification.
Correct.
All existing industrial unit. This is the language, Your Lordship.
Correct.
All existing industrial unit. Existing means that the definition is itself. There is a definition clause. In that definition, existing means all existing industrial unit which are existed prior to the effective date, prior to 1st March to 96.
Where's the definition clause?
Your Lordship, that definition clause is in the compilation.
225. 225.
225.
Doesn't support your contention.
Your Lordship. If it existing industrial unit 2.2 means an industrial unit where fixed capital investment has commenced before the effective date.
So that is very different.
Your Lordship, that is here. That is here. Not existing, not small scale, medium scale. That is here. Your Lordship, I'll go to the annexures.
No.
Sorry.
Before you go to the annexures,
Your Lordship,
the existing industrial unit doesn't, the definition is not that the unit should have existed prior to that date. That's not the definition.
Yeah, let's say existing industrial unit means an industrial unit where fixed capital investment has commenced before the effective date.
So all that it required was some investment to be made before the effective date.
Exactly. Yeah,
so whether that investment resulted first in the first phase as an SSI, in the next phase as a medium scale, there is no prohibition.
Your Lordship is all right. Your Lordship is right. Your Lordship, here the investment, first capital investment has been started on 3rd May 96. So that is after the effective date.
All right.
So the government decides that he cannot avail the exemption so far as EMD is concerned. Only new industrial unit he can avail.
Maybe not, because
Your Lordship, the language is all existing unit. And existing unit definition, industrial unit definition clearly says that the commercial first fixed capital investment has commenced before the effective date.
So he's treated as a new industrial unit.
Exactly, Your Lordship. New industry, there is no objection, and that has been allowed.
So for new industrial unit, for which capital investment started after the effective date. Right. All right.
Now, Your Lordship, may call it on to Annex 7.
Right.
The impugned order, Your Lordship.
Right. So that's the short point, really.
Only that is the point, and only so far as the EMD portion that has been disallowed.
So he says, since I have done well, I satisfy all your requirement, why should I not get an EMD benefit? That's his question.
That due to the prohibition in 5.7, only that has been.
So why don't you answer that alone, Mr. Rai? That's the only point.
That's the
5.7.
Yes, 5.7. Lordship, in the counter affidavit, it is no doubt, my lords, it is undisputed that I have established 3 killing and I have upgraded to a medium scale unit.
The only question is, are you to be treated as an existing industrial unit? Yes. Or are you a new industrial unit?
I am a new industrial unit. There, Lordship will kindly see one thing. My lords, suppose a entrepreneur who has purchased a piece of land prior to 1396, but establishes his plant machinery building after 1396,
will be a new
and goes into commercial production. Yeah, he will be treated as a existing unit.
No.
Yes.
No.
Lordship, I'll again turn.
You only bought the land.
Yeah, I have brought the land after the IPR has come into force. And I started the production after.
So 1396, what did you do before 1396? What did you do after 1396?
That exactly, my lords, I'm going to say, my lords. Lordship may kindly permit me. Now, Lordship, take an example. Let's say X.
No, in your case, what did you do first?
I purchased the land after the effective date. I went into production after the effective date. I am not denying that fact. But I am saying, my lords, what I am saying is this.
Yes.
Let us say X. He had purchased a land prior to 1396.
Then it's a very different thing, sir.
No.
That is not your case.
My lords, that is the question is, my lords, how a person or an entrepreneur who starts commercial production after the effective date, but he has made initial investment prior to the effective date, he will be entitled to get the exemption of EMD, expansion, modernization, diversification. But whereas the person who has purchased the land and started after the effective date and has started the production after the effective date, he will be denied. That is the thing, my lord.
So he'll be treated as a new industrial unit.
Lordship may kindly see, I'll take, my lord, since perhaps I'm not been able to. Lordship will
No,
kindly.
Mr. Rai, the fact remains you did get incentive as a new industrial unit.
Yes,
Ah.
as a small scale industrial unit.
Whatever. So you were treated as a new small scale industrial unit.
And
correctly.
later on I was upgraded to medium
so
scale unit.
We are only now on 5.7.
Yes.
The fact that you are upgraded also cannot be disputed.
Yes.
Whether in your upgradation you are still entitled to incentive is the short question.
Yes. Whether I am entitled to get the as a medium unit when I am upgraded to the medium scale unit, whether I will still be after deducting what I have received, the incentives, I'll get or not.
No. So now you've abandoned 5.7 then.
Yes. Yes.
So you're not looking for EMD.
I am not for the EMD. I am not. And now, my lord.
So you're saying subtract all the benefit I have got as
yes. Yes.
And whatever remains, you give it to me.
Give it to me.
I don't know. That's not the policy is not clear on that, sir.
No.
Unless the policy actually permits it, we cannot just start adding paragraphs to the policy.
No, my
See,
lord.
this is not even a legislation; it's a policy.
It's a policy. Correct, my lords. Can I take your lordships to? Can I submit for 5 minutes, my lord?
Yeah. So what you're saying is, don't punish me for being a good boy.
My lords.
Yes, you're saying don't punish me for being a good boy.
Lordship will kindly see.
Yes.
On what ground they denied. Now, since on what ground this EMD has been refused?
No, you have given up EMD, sir. You are now telling us, forget about EMD. I want to get benefit as a new medium scale unit.
Yes. Now, my lords, now, so far as my learned friend has pointed out, for that reason, my lords, and for better appreciation of your lordship, I'll take your lordship to page 58. Why I was not given this EMD. Can I take your lordship to page 58 of the writ petition of the state's counter affidavit?
Yes.
Petitioner's unit is a new industrial unit under IPR 96 and undertaken EMD during the operation period of Industrial Policy 96 as per the provision of clause para 5.7 para 2 of the Industrial Policy 96. This EMD portion is not eligible to get cell tax incentives as this is new industrial unit. The letter issued by the opposite party number 5 as per Annexure 7 to the writ petition is legal in confirming to the state level state government in industries department letter number so and so dated by 22/10/2001 which states that consequent upon issue of finance department notification number 140-141-17/2000 and sales tax benefit can be extended any more amending paragraph of 5.7 of that IPR of the IPR Industrial Policy 96 which may lead to violation of national policy. What is that national policy, my lords?
Anyways, read on, sir.
Yes. Admittedly, accordingly, the government have considered not to make any amendment to this provision of IPR 96.
So 1 minute. You be clear, sir.
Yes.
Are you harping on EMD or are you giving up EMD? You first be clear on that. If you're harping on EMD, we will analyze this paragraph.
Yes.
If you say, sir, I am not wanting EMD,
yes,
then we will not worry about this paragraph.
Okay. I bow down. I am happy.
No, but you're going to get caught in the another thing then.
And I will not contradict it.
No. So if you give up EMD,
Yes,
then
I'm giving up EMD.
You have to say I'm still entitled as a new medium scale unit.
Yes, that much I can say.
Where does it permit you as a new a medium scale unit?
Yes, that is because of the fact matters, they themselves have, I'm sorry, matters. They themselves admit that I am a medium scale unit. When I have upgraded, the earlier PMT certificate gets cancelled.
Yes.
And another certificate is issued by the DI.
Correct.
And corresponding rule has also been enacted for the notification. For a minute, say, see rule entry 43A. May kindly see the chat I have given.
No. What did you ask for? You asked for EMD.
Yes.
Now you are giving up the EMD before us.
Yes.
But originally you asked for EMD.
Yes.
Now we have to only test the correctness of their decision refusing you EMD. That is the scope of the petition. Yes.
Can Laxmi see 43A of the red chart?
Right.
43A is meant for the medium scale units of 96.
Right.
That is on purchase of the raw materials which goes directly into the finished product. 43A.
Right.
And the fact cannot be changed in any case of the matter.
Right. No, then don't go under the policy then.
Balance?
No. 43A is
43A list A. List A. That is the exemption list.
Right.
That is also previously there. That is also there. I think there is no difference in between small scale and medium scale, except that EMD. Exactly, Your Lordship. Your Lordship, there is no difference. Small scale, there is a certificate and there is exemption raw material 7 years. Everything is same 7 years, 6 years, 5 years.
No, what I meant to say, my lords, corresponding notification has also been issued by the state government so as to facilitate the medium unit to enjoy the incentives on purchase of raw materials.
No. So the short question was, are you entitled to the EMD benefit or not? You were saying I am entitled. They have said you are not.
Yes.
We have only to decide whether they were correct or wrong.
Balance.
So we don't agree with you there. We think they are right in saying you're not entitled to EMD.
Balance.
We'll pass the order, sir. All right.
Great.
There is a counter affidavit on behalf of the government also.
All right.
I have given that. I've read out.
Right.
Special weekly item number 7.
Well, item number 7, I am appearing for the opposite parties. The impugned order is at page 48, annexure 3. This order they have challenged.
My lord, may I pray, my lord? I take assistance from my friend. I don't have a file, but it is a order passed on 2002.
No, but let him first make out a case, sir.
Where the petitioner, my lord? That's why I'm praying, my lord. Can it is 7 days time?
No. We're not adjourning, sir. We'll pass it over. You just get familiar with the matter and come back.
My lord, lordship, I have that order. I take the assistance from my friend and take the order. That is order dated 4/12/2002, my lord.
Annexure 3.
Annexure 3. And lordship may come to the paragraph 3, last 4 line, man. He was working.
He is already deposited in this court that amount.
That amount.
Mr. Sarangi,
My lord.
you already deposited the amount in court.
No, my lord, I was not directed. Mr. Padhi was directed.
That's why I am saying that, my lord, I take the instruction in the mail if this amount is deposited at the court. But now this thing is this amount in 2002, that to amount of 46,499 is.
So that's it. Let it be returned to him, sir, with whatever interest. Let it be returned to him.
But he is not entitled to get it, my lord.
You make out your case. If you have recorded it without notice to him, then he's entitled to it. The short point is, did you issue notice to him before recovering it?
Yes.
You show us that you did issue notice. That's the end of the matter.
And that the instruction I don't have because this
Not
file is not with
instruction.
me.
There's no need for instruction. You just show from the record.
Definitely. I don't have a record. That's why I'm telling. But the question is here, my lord.
No, you tell us.
The employee
There must
of
have
this
been first ground in your writ petition will be, I have issued notice. So let us read that ground. And this is the wife, the employee's wife who has come. Correct, Mr. Sarangi?
Yes, madam. Wife and children.
As an LR.
Yes, he has expired on 11/3/2019. 1990, what it was reflected in the order.
99, sir. That is even before the CAT order.
The long back he has expired. Yes.
So just forget it, sir. Let her get this 40-odd thousand. Let her get it.
But the only question, if there's money with him, recovery is a different issue. Now the department will refund the amount to them.
Already. You have already deposited in the court pursuant to the orders of the court.
Yes, my lord.
So let it go to her, sir. We'll dismiss the OA. The money be released to the money deposited in this court shall be released to the opposite party on proper identification. She is a resident here, sir, Mr. Sarangi?
No, my lord.
May I pray one thing, my lord?
Yes.
This amount was deducted the electricity bill and 48,445 in that period of time. So electricity bill and amount was there. That's why interest is paying to them. Court will pay the interest.
Yes. They must have put it in FD. If they've not, then poor woman she'll get whatever is there. That's it. All right. We'll pass the order. Dismissed. Right.
Lakshmi, reflect along with me, Mr. Bhokta.
Yes. All right.
Weekly list item number 8, special utility.
Item number 8. Earlier, Mr. Ganeshrath was appearing and conducting case. My pedigree, my paternal uncle died on 22nd. So even though I prepared, but not thoroughly prepared.
It's all right. We'll help you, sir.
My lord, in this case, what has happened? This is that revision ADM's order cancelling the lease. The petitioner is a purchaser. He was not heard. Normally, in this type of cases, your lordship is remanding matter that the petitioner will be re-noticed and the matter will be reheard. Because he has purchased the land before cancellation of the lease.
All right.
So that remand order.
So he has done your work for you. That being fair counsel.
Even though I prepared a short note and supplied to him, but I'm not thoroughly prepared.
No, you have not heard him.
That order.
He has made sure you don't have to argue. You're getting your relief. He is being such a fair counsel today.
No, he's always fair, my lord. My senior is always fair.
All right. We'll pass that order. So we'll just fix the date.
I am supplying a date chart I prepared, my lord.
All right. Hand it. So you appear before the ADM on 6th April. All right. And we request him to dispose of within 4 months.
Deep low place.
To appear before the ADM on 6th April. To dispose it off within 4 months. The impugned order is set aside. Matter is remanded. If any record has been called, it will be returned to the ADM forthwith.
The impugned order may be valid till disposal of the
status quo will be there, sir, not impugned order.
Yes, not impugned order. Status quo will continue.
Because there is a status quo.
All right.
Leave low place.
Special utility list item number 9.
May I please your lordship? I am speaking from VC Millers.
Right.
Millers, here the short point is, Millers, the Honorable District Judge Fulbani conducted an interview for appointment of some peons.
Yes.
20%, 15 persons were selected.
Yes.
Now Millers, everybody has been appointed except the present petitioner who was at serial number 14.
Yes.
This 15th man was appointed. His appointment was cancelled because he was not appointed as a candidate peon. But subsequently, this honorable court minutes, I have given the certified copy of the order in WPC number 11301 of 2004.
Must be here.
His appointment has been upheld by this honorable court.
So there is nothing called a candidate peon anymore.
Well, be that as may be, he has been upheld, but I am the only person, though I am senior to him, I have not been given any appointment.
That's all right. So you are now 47 years old. There's no question of appointing as a peon now.
45. Another 15 years I can work, Milords.
No, please.
Milords,
the whole system of candidate peon is over, sir.
No, Milords, I am not at fault. I have challenged the appointment since 2003. The matter is pending since 2003, Milords.
What to do, sir? What to do? We can't now revive a policy just for you.
No, I was never a candidate peon, Milords. I was selected to be a peon. I was not a candidate peon. If your lordship will kindly see the next annexure 2, the candidate peons list to observation was shown. I was never as a candidate peon. Page 8 of the writ petition, Milords. I was never a candidate peon.
No, you were challenging this order, correct?
Yes. No, I am challenging. Everybody has been given appointment. Person below me has been appointed. He was also not a candidate.
They were appointed as candidate peons.
No, he was never appointed as a candidate peon.
Sir, I am talking about annexure 2.
Annexure 2, neither I was appointed as a candidate peon or the 15th man was appointed as a candidate peon. He was directly selected. If your lordship will kindly see the list, and his name is Gangadhar Manoj Kumar Mishra. He is the 15th man as per annexure 1. I am the serial number 14, Milords. Everybody has been appointed. Up to 1 to 7 were appointed candidate peons. The rest were not appointed. They have been subsequently appointed. For no fault of mine, I have been deprived of.
What appointed as what?
Peon, Milords, as peon. I have given all those appointment letters, Milords. As peon. They have been observed as peon, Milords.
Let's see that.
Yes, Milords. If your lordship will kindly see annexure A by annexure 6. Sri Narasingha Behera, he has been observed and posted as a process server in the court of civil judge Baliguda. The next man, Sri Chandrasekhar Madhi, he is candidate peon, but they were never candidate peons. He has been appointed as class 4 peon. And if a lordship will permit me to refer to page 26 of the counter affidavit.
Yes.
Paragraph 10. I am not reading many things to disturb your lordship. In reply to the averments made in para 10 of the writ petition, it is humbly submitted that facts stated under this para are true. On 26/8/2002, Sri M.C. Rai, ex-district judge Pulwani, appointed 2 candidates from the selection list, serial number 13, Jharia Mahapatra and 15, Manoj Mishra, as class 4 employees without enrolling them as candidate peons. So this question doesn't arise. I am the 14th man. I have been left out. And if your lordship will further affidavit, my lords will see page 31. He was terminated. This honorable court has now again reinstated him. There, page 31. Thereafter, M.C. Rai, ex-district Fulwani, hurriedly adopting pick and choose method, has given appointments to outsiders directly without any interview. Moreover, M.C. Rai has also given an appointment to serial number 12, Pramod Kumar Sahu, 13, Jharia Mahapatra, 15, Manoj Kumar Mishra, without enrolling them as candidate peons. And Fulwani, then, due to such activities, I, Honorable Administrative Judge, there I am not concerned, but ultimately this Honorable Court has upheld the appointment of Mr. Manoj Kumar Mishra. He was terminated on the ground that he was not engaged as a candidate peon, but he has been appointed. I am a poor man, Milords. I have challenged this since 2003. I am struggling for no fault of mine.
Stand.
Your Lordship, page 8, annex to page 7, annex to 1.
Yes.
Admitted fact, there is 15 candidates were selected.
Right.
Out of 15 candidates, 7 were appointed at a Lordship at annex to 2.
Yes.
Out of 8 candidates,
those first 7 in that list were in fact appointed as candidate peons.
Yes, my lord.
That
is the admitted fact.
I kept telling him, says nobody is appointed candidate peon. In fact, from this list, this select list, you appointed the first 7 as candidate peons.
As candidate peon. Yes, my lord.
So his grievance was the other 2, without first appointing them as candidate peons, you straight away appointed them peons. That was his grievance.
Yes, my lord. What is his grievance, my lord? That as serial number 15 has got appointment, he should get appointment. And it is also admitted fact 12, 13, 15, they were appointed when it subsequently came to the notice, all 12, 13, 15 were issued notice and they were terminated.
But 15 managed to get it back because of the court's order.
12, serial number 12, approved, my lords, in WPC number 5527 of 2005, which were dismissed. And serial number 13, he did not approach. He was terminated. But subsequently, serial number 15, he approached, my lords, and got an order.
No, because he's physically handicapped. That's the difference.
And in entire case, his claim is a negative equality.
Right. Right. We'll write the detailed order, Mr. Das. We are not inclined to. Dismissed.
Because they approached and they succeeded.
No. That's correct.
I have approached 2003.
We'll write a detailed order, sir. We'll read.
Special weekly item number 10. Special weekly list item number 10.
None appears dismissed, not possible.
Special weekly list item number 11.
Item 11, in the meantime, the petition has been died. I have substituted the legal heir of the petitioner 1 week time.
No. When did he die, sir?
Last December, December 21.
So it's already late. You tell us what the matter is about.
Challenging the order of the Lanet State Education Tribunal. State Administrative Tribunal.
Let's read the order, sir.
Page 52 of the petition, annex of 6. Challenging the appellate order manner. In appellate order, the compulsory reversion to compulsory retirement manner. No, 1 week after I have not gone through this.
No. We are not adjourning, sir. We'll pass the order. Dismissed.
Right. Special weekly list item number 12.
Lordship, I am the VC, my lord. I may be allowed to argue in this case, my lord.
Yes.
Wherein the petitioner was the president on Cooperative Society Ltd.
Right.
Before this writ application challenging the order dated 2/2/1999, passed by the under Annexure 1, passed by the presiding officer, Labor Court, Sambalpur, my lord. This order is ex parte order. Lordship, the fact of the case, the opposite party number 2 was one of the employee of my petitioner society. Basing upon a criminal case, he
Did you deposit this 50% amount?
Perhaps the deposit I have the case of 2003. Perhaps deposited.
Why did you say perhaps deposited?
Lordship, case of 2003. I have joined.
No, it is not deposited, sir. 1 minute.
My lord.
Just tell me, has it been deposited? What was the age of this opposite party number 2?
Opposite party number 2, my lord.
What was his age?
Age, lordship. So for the age group concern, I have no documents, lordship. On record, I have no documents with me, Manna. Also, there is no contact number of also petitioner.
Why did you remain ex parte, sir?
Lordship, enter order, lordship, Annex 1.
No, why did you remain ex parte?
No notice issued, my lord. While execution case was initiated by the opposite party number 2, thereafter the management came to know that the order was ever having passed.
Without notice, how would you be set ex parte? Would not be set.
The order itself shows, my lord. Lordship, there is nowhere mentioned you should notice the opposite party.
If the opposite party is not around, what was he working as?
He was the night watcher.
Why do you want to chase all these people, sir? They'll get nothing. Some 20,000, 30,000, you will be chasing them for this.
This is expert.
Not deposited. So even the 50% is not deposited.
Yes, Lordship, may disclose.
If you have not deposited, that's the end of the matter. You say
on that ground, Lordship.
Yes. This is a challenge by the management to a award dated 2nd February 1995, passed by the Labour Court, directing.
Lordship, 99.
Okay, 99. Directing reinstatement of the opposite party workmen within 30 days, with back wages from 13th August 1995 till the date of his reinstatement. While directing notice to issue, an interim order was passed that the management should deposit 50% of the awarded amount within 3 weeks in the shape of a bank draft in this court. That interim order has not been complied with, despite and on 24th January 2007 itself, that interim order was vacated. Paragraph. Having heard learned counsel for the management and considering that even the interim order passed by this court has not been complied with, and given the long pendency of the present petition, where no effective relief has still date been granted to the opposite party workmen, despite succeeding before the Labour Court. This court is not inclined to interfere. The petition is accordingly dismissed.
Special weekly list item number 13. Item 13.
None appears dismissed for non-prosecution.
Special weekly item 14.
Infructuous, your lordship.
Counsel, the petitioner states petition has been rendered infructuous. Is disposed of as such.
Special weekly list item 15.
May be, your lordship. This is the authority issue the ration card illegally to some person, my lords. Those are not coming in the criteria, my lords. So I filed a repetition to the collector Baleshwar, Annexure 3. That is pending, my lords.
1 minute. Which matter are you appearing in, sir?
15.
What is your petition number?
21616.
We are on the special weekly list.
Special weekly list. I am appearing in item 15 in VC, Miller.
Yes.
Here, the short question involved is whether railway will be liable to pay interest on the DCRG and the commuted value of pension when he was prohibited under the rules of the pension rules not to release the amount till disposal of the disciplinary.
What is the amount involved, sir? Suppose you have to pay that interest. What is the amount you will pay?
He is asking, my lord, from 1995.
What does it work out to? What does that interest amount work out to? We leave that question of law open, sir. All these are pensioners. They're going to get nothing. We don't even know if they'll be around. What is the age of this man?
The age is too much. He has retired in 2000, in 1997. Yes.
Yeah.
In fact, the disciplinary proceeding was pending. The rules provide that it cannot be
question
released.
the question raised in the present petition is left open for decision in an appropriate case, considering that opposite party number 1 retired way back in 1997, and this writ petition itself has been pending for over 18 years. Petition is accordingly dismissed, leaving the question of law open. The interim order stands vacated.
Not be treated as a precedent. Not to
Same
be
thing,
treated.
sir. Question of law open means it won't be treated as a precedent.
Obliged.
Special weekly list item number 16.
None appears dismissed on prosecution.
Special weekly list item number 17.
None appears dismissed.
My lords, I am for petitioner. I am the Prabhu
All
question.
right, tell us, sir. Tell us.
My lords, I am led by my learned senior ASGI. My lords, the difficulty, your lordship is generally not allowing the time. I understand, my lords. My difficulty is the record is not traceable because
So
of.
whenever you trace it, we are permitting that, sir. Whenever you trace it, you file an application, revive it.
My lord, that
the petitioner states the file is not traceable, the petition is accordingly dismissed with liberty to the petitioner to revive this petition as and when they are able to trace the file. All right.
Well, if the cause of action survives.
Sorry?
If the cause of action survives.
What cause of action? Cause of action will revive when you file the file.
I'm obliged.
May I submit, my lordship, village judge. These old files are listed.
That's why, sir, whenever you hunt down the file with great vigor and file an application, we will restore it with equal vigor.
I have vast experience about this transactional period, my lord.
No.
The old files are coming at least 1 week or 2 weeks time. We will get obtained this.
All right.
Special weekly list item 18.
Yes.
18 lordship petitioner is challenging one terms of one tender process lordship. That is NFC 2 page 47. I think it will.
All right. Counsel the petitioner that this has become states that it's already become infractious, disposed of as such.
May I say lordship permit me to approve if further cause of errors lordship.
Not necessary. It's a 2005 matter. Yes.
Special weekly item number 19. Item number 19.
19, my lord, I am for OP number 1 and 2.
All right. None appears dismissed on prosecution.
Special weekly list item 20.
Item permitted to withdraw.
Permitted to withdraw. Dismissed as withdrawn.
Special weekly list item 21.
None appears dismissed on prosecution.
Special weekly list item number 22. 22.
None appears dismissed on prosecution.
Special weekly list item number 23.
Item 22. So item 22 has become infractious.
All right. 22 is infractious.
Special weekly item 23.
Okay.
Dismissed on non-prosecution.
Special weekly list item 24.
The matter has become infractious.
All right. 24.
24, I am for IDCO, my lord, actually.
All right, sir. All right.
I am also there, my lord. OP2.
All right. All right.
Item 23, Union of Pina is there.
All right, sir. All right.
Special weekly list item 25.
Item 25, I am appearing for in the first matter. There are 3 matters. I am appearing for the petition of the first matter. This is against the order of DRT. I want to withdraw the writ petition to pursue available alternative remedy. Your lordship has in identical case passed.
All right. Same order. In item 1.
Cases, I am for the opposite. Other 2 matters, I am not appearing. Other 2 matters, petition matter, they have to approve the DRT.
You are for the opposite party, sir. Other 2 matters, none appears dismissed on non-prosecution.
Beg to pardon, my lord. Beg to pardon, my lord. Item number 19, my lord.
What is it?
My lord, item number 19, my lord. I am appearing for the petitioner, my lord. When I coming to the from Sirasta, I could late, my lord. When I came from my Sirasta, so it became late, my lord.
It's okay. We'll hear you. Tell us what 19 is about.
May I please your lordship?
Yes, please.
Here, my lord, I am challenging the order passed by branch manager, Keonjhar branch of Orissa State Financial Corporation for taking over the possession of the petitioner's land, my lord. The fact of case is
What
that,
is the amount due, sir?
my lord, the amount dues. My lord, as per the counter, amount dues is 9,13,603, my lord.
So how much amount are you willing to pay, sir?
My lord, my humble submission before your lordships, my lord, section 29 is not applicable to the me, my lord.
We'll go to all those fine questions. You tell us what is the amount you're prepared to pay now.
My lord, I am not a borrower, my lord.
What are you?
I am the guarantor, my lord.
So what?
My
It's
lord,
equally
so-
applicable to you too.
So, my lord,
29 applies to both.
my lord, section 29 is not applicable. Section 13(1), my lord, is applicable as per the decision of our honorable apex court, my lord.
All right.
My lord, now I am placing the.
All right. I think we applied it. Who's for the OSFC? Mr. Tripathi was there on the first call. Tripathi was there in the first call, but you were not there. So you'll have to get in touch with him. We'll just pass it over. We'll pass it over. You better get in touch with him.
Special liquid list item number 26. Item number 26.
None appears dismissed from numbers.
Special weekly item number 27.
27, I am for the department, opposite party.
None appears dismissed from numbers.
My lords, may I be pardoned? Item number 24, my lords.
You'll have to wait, sir. You'll have to wait. Yes.
Special weekly list item number 28.
None for the petitioner, my lord.
Yes.
I prepared the date set, my lord, supplying.
Yes. So if you do not mind, if you can remove your mask and speak, it will be clearer, sir.
Challenge is, my lord.
Yes.
To the annexure 11.
Yes.
And it starts at page 78.
Yes.
Reference was, I'm coming directly to the point, man.
Did you deposit this 20,000?
20,000 was depositing of 20,000 was that order was withdrawn. He is getting 17 BVs.
I see. All right.
That order was withdrawn, substituted,
All right.
modified. Sorry, modified. Then, my lord, page 70, reference was whether the action of the management of IGNOU, Indira Gandhi National Open University Study Center, Government College, Raulkela 6.
So we'll do one thing. We'll take it at the end of the board. We'll take it at the end of the board.
Okay.
Special weekly item number 29. Item number 29.
Dismissal non-prosecution.
Special weekly list item number 30.
Your Lordship, item 29, second matter.
Yes.
Your Lordship, second matter that with Your Lordship, in this case, my Lord, at the time of filing of writ petition, petitioner has 89 years. So no instruction is there.
All right. In 29 second matter, you say no instructions.
May I please your lordship, my lord, item 29. It is a covered matter, my lord.
Whom are you appearing for, sir?
I am in person, my lord, in item number 1, my lord.
No. What is your writ petition number, sir?
Item 29, my lord.
Writ petition number, sir.
Writ petition 4486 of 2008.
You're Mr. Rautre.
Yes, my lord.
Tell us, sir.
My lord, this is a case, my lord, against the order of member board of revenue.
Right.
The impugn order was on 5/5/67, and the revision was filed in 2003. Similar matter was before my lord earlier in 12,801 of 2007 and 14,263 of 2007. In both these matters, my lord, limitation was there. They are 25 years after the revision was initiated. And this honorable court has remanded the matter to member board of revenue for fresh adjudication after getting into consideration the limitation. This is the order, my lord. Similar matter, it has been referred to in that cause list also. The numbers are there also. Connected matters, my lord.
All right. In view of the order dated 29th July 2017, in repetition civil numbers 14263 and 12801 of 2007, the impugned order here is set aside and the matter is remanded to the member board of revenue to adjudicate the maintainability of the very proceedings before under the OEA Act as directed by this court in the said order. The matter will now be what are the OEA revision case number 80 of 2003 will now be
2010, my lord, that is relating to land, my lord. Ex-intermediary land, I am a permanent.
No, sir. What is the case that has to be revived before the member board of revenue? It's OEA revision case, correct?
OEA 80 of 2003
will now be revived before the member board of revenue and will be listed there for directions on 21st March 2022. All right.
Special list item 30. Item number 30.
None appears dismissed, not possible.
Special list item number 31.
But 31, I was appearing initially, but subsequently the client has taken the file. I am no more the counsel.
All right. None appears dismissed, not possible.
Or we never noted our appearance.
All right.
Special list item 32.
None appears dismissed, not possible.
My lord, 32. I'm pardon. 32, my lord.
Yes.
My lord, in this case, I have filed an affidavit petition that for service of notice against the opposite party order file rule 20 because there are 58 numbers of opposite parties against whom this honorable court has passed the order for service the notice. But it is too difficult because
No, you tell us first what is the matter about.
Matter is that they kindly see the
another 38B, correct?
38B, my lord, the number kindly see the final order. Let it be, my lord. I will be allowed to withdraw the matter.
Counsel, the petitioner seeks leave to withdraw this petition to pursue other remedies. Dismiss is withdrawn with liberty spared. All right.
Special list item 33.
I am there for the opposite parties.
None appears dismissal, not prosecution.
Special list item 34.
34, my lord. I prepare a dead chart with citation. This is a matter relating to Industrial Dispute Act, relating to non-promotion to the higher post.
We'll take it at the end of the board. Take it at the end of the board.
Special list item 35.
35, my lord. In practice, madam.
Counsel, the petitioner states the petition is in practice. This is post of
Special list item 36.
My lord, item 36, all the cases are filed by the state against the order of the tribunal. And what I have taken instruction in this matter relating to the appointees made by the appointment Mr. K.C. Guru, government has regularized certain appointments. I will have to take instruction about these fours, whether these fours have been regularized or not.
We'll pass it over, you take instructions, sir. Pass over.
Special list item 37.
None appears dismissal number.
I am appearing for the OP bank.
You have to speak into the mic, madam.
I am appearing for the opposite party bank.
All right.
Special weekly list item 38. 38 below. Connected matter has been listed on
38, my lords. I received counter as last statement. I am filing rejoinder today, man.
This is writ appeal, sir.
30?
W187.
Oh, sorry.
None appears dismissal number.
No, I am for the petition. I am for the applicant.
Yeah,
in this case, the connected WPC has not been as per the endorsement of the registry.
All right, you tell us what the matter is. First, remove your mask and speak, sir, if you do not mind.
Sorry.
Tell us what the appeal is about.
Two matters are identical. Another matter is listed on 3rd March of 2000.
All right, list on 3rd March. All right.
Along with the connected matter.
All right. What is the connected matter?
That is also 13. Serial number 38 of the weekly list. That is connected 186 and another is 187.
All right. List along with 186 of 2010. All right.
Consultation matter.
Right.
Special weekly list item 39.
My lord, I filed an amendment petition to the writ petition. Only the submission in respect of question of law I have amended.
What's the matter about?
Matter, my lord, regarding the non-payment of salary of the petitioner since 1997, my lord.
All right. We'll just take it at the end of the board, sir.
End up?
We'll take it at the end of the board.
Special weekly list item 40. Item number 40.
None appears dismissal number.
Special weekly list item 41.
41 for the Southeastern Railway. If the case, the similar cases are already been disposed of by the Honorable Court, and my lord has allowed the writ petition filed by the Union of India in WPC number 13925 of 2008. In that case, there is 6 years delay for filing the case. Here is the case 11 years delay, my lord. Virtually, this notification made for regular employment of casual labor.
Where is that order?
My lord. That order is copy, yes, writ petition number 13925 of 2008.
Writ petition is there.
This is order dated 21/8/2019, my lord.
1 minute.
In 96 notification, there is no objection, my lord.
It was valid till 31st/10/1996. Central government.
Who's appearing for the opposite party here?
Opposite party. Maybe not there.
The notice never went in all these years.
Yes, my lord.
Notice has not gone. They're not obviously interested in enforcing the order, sir.
But it is a case, Lordship may see annexure 1, page 25. This notification was made on 16/5/2096.
So if he ever goes for a contempt, we'll permit you to revive the petition. You say in the over 11 years during the pendency of the present petition, notice was not even issued to the opposite parties. Full stop. It is not even known what the current status of the opposite party number 1 is. Full stop. Clearly, he has not even moved for enforcement of the impugned order of the CAT. Full stop. In the circumstances, the court sees no purpose being served in entertaining the present petition. If at all, opposite party number 1 moves to enforce the said order, it will be open to the petitioner to revive this petition.
May I pray, my lord, may reflect about the dismissal of the another writ petition that is.
Whenever that is revived, you can tell us about that, sir. I don't think that man is ever going to move for enforcing the order. Yes.
Satya Sindhu Kashyap is appearing with me, lord, may reflect his name.
All right.
Special weekly list item 42. May I please? Page 11 is the impugned order, my lord, passed by the State Administrative Tribunal.
Who's for the other side?
Baidhar Saw is
I am for the opposite party, your lordship.
Sorry, my M. Pratap.
Sorry?
I am for the opposite party, your lordship. OP number 1.
What is the current status, sir? There is no stay granted of the impugned order?
Yes, my lord. Stay has been granted, my lord.
When was stay granted?
1/8/2011. And during pendency of that original application, that post was abolished. 1/8/2011.
Then what survives then?
So post is tribunal order is that to give him appointment.
So even if else a contempt, there's no post, you don't have to comply with.
I have two submissions, your lordship.
Yes.
Subject to your lordship approval. My lordship, may kindly, I have given a date chart, your lordship.
Then we'll take it at the end of the boat. All right.
Well. Special weekly list item 43.
Your lordship, item number 43. Your lordship, SLP is pending. Your lordship may kindly turn to the with matter, order dated 10th January 2013.
It's still pending the Supreme Court.
Your lordship, the petition has stated that it is covered by NALCO in the judgment of NALCO, and against that NALCO judgment we are before Honorable Supreme Court, and that those SLP is pending. So your lordship, right, my humble submission.
We'll defer it. All right. It is stated that the SLP is filed by the department against the judgment of this court in National Aluminium Company Limited versus Deputy Commissioner of Commercial Taxes 2012 56 VST 68 is still pending in the Supreme Court. In that view of the matter, these petitions are adjourned sine die, awaiting the judgment of the Supreme Court. It will be open to the parties to apply for revival, for listing of this petition after the judgment of the Supreme Court.
My lord, imprimatur to continue, my lord.
Obviously, sir. Yes.
Your lordship.
Special weekly list item number 44.
May I please, your lords? Here, the matter relating to regulation 2, my lords. The impugned order annexed 3, the officer in special duty had resumed the restore the land.
All right, we'll take it at the end of the board, sir.
My lord.
Special weekly item 45.
May I please, your lords? My lordship, the petitioner has expired in between, my lord.
All right. Counsel, the petitioner state the petition is expired. Nothing survives in the petition. It's dismissed as such.
Special weekly list item number 46.
46, my lord. The petitioner is the driver of this honorable court who has imposed punishment of the reduction of 2.
You are for the petitioner, sir?
I am for the petitioner.
We'll take it at the end of the board.
My lord. And
end of the board, sir.
Last door. Special weekly list item number 47.
47, probably when the interim order was vacated and thereafter we are directed to proceed with the matter.
Whom are you for, sir?
Sir, I appear for OP number 2 and 4, my lord.
All right. None appears for the petitioner. Dismissal not possible.
Special weekly list item 48.
None appears. Dismissal not possible.
Special weekly list item 49.
Your lordship, no instructions.
Counsel, the petitioner, she has no instructions.
I am for the
Your lordship, I'm appearing for your lordship, I'm appearing for IDCO.
All right.
For Union of India, my lord.
All right. Okay. All right. This is a letter petition received way back in 2012. And no orders have been passed for over 10 years now. The court therefore does not propose to act on it at this stage. The petition is disposed of.
Special weekly list item number 50.
None appears dismissed for non-prosecution. Let's call out the other case. Supplementary.
My lords, I may be pardoned. My lords, item number 24, I could not connect at that moment. My lords, I may submit that the matter has, we want to withdraw the matter, my lords.
All right, 24, you say counsel the petition seeks leave to withdraw this petition. Dismisses withdraw.
Greatly obliged.
Now, weekly list. Trace admission item number 1, WPC 18303 of 2014.
None appears dismissed non-prosecution.
Weekly list item number 2.
None appears dismissed non-prosecution.
Weekly list item number 3.
None appears dismissed non-prosecution.
Weekly list item number 4.
This has been listed mentioning as a PIL, but this is not PIL, man. This is personal interest. Case has been filed under NH Act, my lord.
Whom are you for, sir?
I am for the petitioner.
I see.
It was listed earlier, my lord, but your lordship has passed 9/2/2022. Land acquisition matter under NH Act, my lord.
All right. Counsel, the petitioner states is not a PIL. List before the appropriate bench on 4th April.
Date be 4th April. A date, your lordship.
4th April. Weekly list item number 5.
May I please, my lord? This is a public interest litigation. The lordship may kindly turn to page 26, my lord. Here, in order to extend the land rights to the farms, the government has prepared a scheme, my lord. The lordship may kindly turn to page 24, the last 2 lines, my lord. The cut-off date was fixed. It was 2017, my lord. The survey was conducted, and the lordship, I have annexed the guidelines under annexure 2. That is the survey, how the survey will be conducted and how the list of the beneficiaries will be prepared, my lord. On the basis of that, the survey was conducted, lists were prepared. Your lordship will just kindly turn to page 116, my lord. That is annexure 3, my lord. 110. Sorry, my lord. 110 page. List under Chaudhar municipality, the list of the slums, my lord. In the 2018, my lord, on the basis of this 2011, the list was prepared. In the list, 9 authorized slums and 8 unauthorized slums are there, my lord. On the basis of this list, my lord, the beneficiaries are to be enlisted for extension of the benefit of land rights, my lord. But surprisingly, your lordship may kindly just turn to page 111, annexure 4, my lord. In 2020, another list was prepared, where is some new slums were added, my lord. So how the list was prepared and how the slums were inserted in the new list, that is unknown, because the cut-off date was fixed to 10th August 2017. But this list was prepared in 2020.
You not made any representation, nothing.
No, my lord, no representation. Thereafter, they have prepared a list, my lord, under annexure 5 to extend certain.
So you make a representation, sir. That's the only way to do it. Otherwise, it will all be disputed questions of fact.
Because this is required to be inquired, my lord.
The only difficulty is it will affect a large number of maybe thousands and 10,000s of people whom we are not even impleading.
And the more particularly the slums who have been.
No, one person will come. The real persons affected are some 15,000 people or 20,000.
Yes, my lord. The real list, the real affected persons have not been enlisted.
Then how are we supposed to deal with these kind of petitions?
My lord, how they prepare the second list, I don't know, because the cut-off date.
See, you are coming as a public interest litigant, correct?
Yes, my lord.
So if we entertain your petition, some 10,000, 20,000 people will get affected, correct?
No, my lord. The list was the past list was prepared on the basis of the cut-off date and on the basis of 2011.
You answer the question. You are not a person residing there.
No.
You are
I am
some
residing
public
under
interest.
Cuttack municipality.
Yeah, you are some public spirited person who's not residing in slums, correct?
My lord.
So if we entertain your petition, will it affect people residing in slums or it will not affect them?
My lord, the slums who are residing there, they have been enlisted under Annex 3.
Sir, my question to you is, if we entertain your petition, will it affect any slum dweller or it will not affect any slum dweller?
No, it will not affect it because the proper persons have been
I'm
already
sorry, we disagree with you.
prepared.
We completely disagree with you on that.
My lord, the list is prepared under Annex 3. That is the correct list. My humble submission before your lordship is that the correct list is prepared under Annex 3 on the basis of the guidelines.
Are the slum dwellers affected by list number 4?
Yes.
Annex 4 list, there is a list of slums, correct?
List number 4, the list under Annex 4 is completely illegal.
All right. So people living in those slums will be affected or not if we quash?
There is no such, my humble submission, your lordship, is that there is no such slums whose names have been included in the list under Annex 4. For that reason, I am before your lordship, because an inquiry is required to be conducted. How they have prepared the list under Annex 4? Because the correct list is under Annex 3.
No. Correct and wrong list. I don't know how you can decide correct and wrong list.
Because they have supplied both the lists. Your lordship, they have supplied both the list.
Representation. This is not the way to deal with these kind of issues, sir, because it will affect thousands and thousands of people. And they are not parties before the court.
The facts are told.
These kind of petitions are only meant to create chaos.
If your lordship,
because affected persons will never be brought to the court. You are sitting in some comfortable place. You will simply sit and file a PIL saying all this is wrong.
No. I am a resident of that place, but I am not a slum.
The actual people affected will never be made parties.
I don't also want that the actual people also should be affected, my lord. But your lord have supplied the list.
No. We are not prepared to entertain this, sir.
Both the list have been prepared by them, my lord.
We say the petition questions the preparation of a list of slums of Chaudhar municipality, claiming that the list has been wrongly prepared. The problem with entertaining petitions like this is that the actual people affected are not before the court, and they will be in such large number that it will not be possible for the court to entertain the disputes arising out of such petitions. Full stop. Consequently, the court is not inclined to entertain the present petition. This will not prevent actually affected persons from approaching the court, approaching the appropriate forum for relief. Yes.
Your lordship may permit
the petition is dismissed. Yes.
Weekly list item number 6.
I will pardon item number 1. My humble submission is let it come along with.
So we have crossed item 1, sir. We have crossed item 1. Yes.
Pardon?
We have crossed item 1. You may have to wait. We are now in the midst of which is the item you are calling out, sir?
I couldn't hear.
Item 6, sir. We are now in item 6.
Right, man. I may pardon. Item 1. I was inside the room, but I couldn't hear.
So the problem is I am already talking loudly, and if I talk louder than this, it will become inconvenient for people.
I couldn't hear. I'm sorry.
I'm also sorry, sir, that I'm not able to speak louder than this through a mic. Through a mic, I can speak only so loudly. Beyond this, if I speak, my throat will get affected. Other people's ears will also get affected. So kindly pardon me also, sir. Yes, carry on with the list. We'll come back to it, sir, when we come back.
I'm not praying for.
Even I am not, sir. I'm only requesting you. Let me proceed with my list. I will come back to your request. Yes.
Item number 6.
My lord, petitioners are inspector of a cooperative societies.
Yes.
That is a group C post of government of Orissa. My lord, they have challenged annexure 3, annexure 3 page 30, rule 10 and 13 of Orissa Subordinate Cooperative Service Recruitment and Condition Amendment Rules 2011. My lord, rule 9. My lord, 2 types of appointments for the cooperative inspector. My lord, one is a direct recruitment, another is a departmental promotion. My lord, the petitioners are a direct recruitment appointed under Rule 9. My lord, by the staff selection of Orissa. My lord, but the promotion appointment is a peculiar, my lord, they will be senior to the petitioner.
You are appearing for the.
Yes, Your Lordship, turn to page 15 first.
Yes.
Your Lordship, see the date of appointment of these petitioners.
Yes.
Your Lordship said the date is 2/3/2019.
Right.
And he challenged a rule of 2011. And what the rule 2011 says, Your Lordship, see page 31. How he is affected? Your Lordship said page 31.
Yes.
Persons appointed the post of Inspector of Society shall rank interest in order in which their names appear in the list prepared under Rule 11 and shall en bloc be senior irrespective of the date of the persons appointed to the said grade by direct in that particular year. No one has appointed in that particular year. He is no way aggrieved.
Anyway, these service matters are before this bench.
And yes, once it was before my lords, and
but there's not part one or anything, sir.
No, it was withdrawn.
So withdrawn and given liberty to filing better
list
application.
before the roster bench. These are not service matters. It's not before us. This before the roster bench.
Virus of this matter is challenged. So it is
28 March.
Virus of the act is under challenge.
Weekly list item number 7.
So the respective benches have been asked to deal with virus of their subject matters.
Weekly list item number 7. Weekly list item number 7.
None appears this is not.
For orders, weekly list item number 8.
None appears dismissed for non-prosecution. In the headline. All right. The order dated 21/2/22 is corrected. And the writ petition is correctly to be indicated. Yes.
Weekly list item number 9.
None appears dismissed for non-prosecution.
Weekly list item number 10.
No instructions, man.
No instructions.
Weekly list item 11.
In this case, it's a transfer free, my lords. In view of the changed law, my lord, the petition is not maintainable.
All right. Counsel if the
I may
petitioner.
be permitted to withdraw to file it before the appropriate forum.
All right. Counsel the petitioner seeks leave to withdraw this petition with liberty to file. Approach the appropriate forum. Dismisses withdrawn with liberty is paid for.
Weekly list item number 12.
None appears dismissed for non-prosecution.
Weekly list item number 13.
I please, Your Lordship. I, Mr. Rautra, am not here. Unfortunately, on that day, Your Lordship, of course, after lunch, there was no court. Just before the lunch, Your Lordship, kindly look Your Lordship's order in the other case. That has nothing to do with this case. Somehow, this 3 judicial officers, 1 additional district judge, 2 of them have retired during the pendency of the application. 1 of them is continuing still, squarely covered by the judgment which Your Lordship, so far the administrative side, the registered administration of the Orissa High Court has have given that copy also. That was during the pendency of this application. You also kindly look to that order of the registered administration to the Home Department. If you also look to that you also can see that squarely covered by the judgment of 2018, where the Supreme Court has said that the fast track court period will be counted for the purpose of pensionary benefit. On that basis, that Your Lordship, in the administrative side, register of this honorable court made a recommendation to the Home Department in respect of these 3 petitioners. The other one is not something different. I'm giving the copy of the order also, which Your Lordship passed on that date. That is that has given. I have given along with the order, along with the copy of the judgment of the Supreme Court, as well as the last page 10, Your Lordship's order in the other case, where the Home Department had returned back on the ground the matter was pending here. If Your Lordship will look to that order because that file is not there, therefore I have given to Your Lordship that copy of the order along with my. And the State Council also asked that it has nothing to do with the other case. It is independently also either here some of that because Your Lordship don't have time today.
Where is that? January 22. The order is not scanned. Main file, see the file.
That copy I have given to Lordship on that date also. Lordship passed orders in the other case. that I have given to your lordship. Both 2 copies I have given to your lordship, along with a copy to the State Council also. In that case, your lordship have said an additional affidavit has been handed over today on behalf of the petitioner, inter alia. It encloses a letter dated 24th August 2021, sent by Home Department to the District Judge Koraput at Jaipur, stating that the pension paper of the petitioner along with the service book are being returned since the present petition is pending before this court, and that it can be resubmitted after disposal. Joint counsel for the petitioner prays that the present petition may be disposed of to enable the processing of the petitioner pension paper. In view of the aforesaid development, the petition is disposed of to enable now the District Judge Koraput to again forward the pension paper with the original service book of the petitioner to the Home Department, not later than. That was that case. But here is the case, if your lordship will look to the register's administration letter dated, this was during the pendency of the writ application in 2020, the writ application of the year 2018. And the administrative side of this honorable court has sent.
Where is this file, sir? 11008. Which is filed?
11008 is your lordship's brief today's. I filed this application.
So show me the 11008.
Order number. Yes.
Or if we just issue notice in this.
Yes.
Notice in the IA.
Yes. Last week.
Just issue notice in the IA, returnable 27th April.
Extra copy of IA maybe. Copy of the IA may be served on.
Yes.
Yes, but I have already served, but I'll again serve.
Weekly list item number 14.
May I please, your lordship? Here we will have a glance, your lordship. The private opposite party of the writ petition, lordship, they have been enclosed the Gochoro land, your lordship, for which we made representation before the authority concerned. Accordingly, under the Appeal Act, a summary eviction is required to be conducted, lordship. But the Tahsildar, your lordship, before whom the representation is pending, that is, your lordship, since 18/10/2019, your lordship, my postal receipts have been paid 20, your lordship.
Petitioner's representation
at Annexure 2.
At Annexure 2 be considered by the
Tahsildar Jaleshwar, your lordship.
Or Tahsildar Jaleshwar, opposite party number 5, and after issuing notice to the petitioners and opposite parties 6 to 16, and after giving them an opportunity being heard, a reasoned order be passed not later than 16th May 2022, and copy of the order be made available to the parties not later than 23rd May. The court clarifies that it's not expressed in any matter.
Obliged.
Weekly list item 15.
May I please, your lordship? My lord, in this case, my lord, the authority illegally issued the ration card.
Have you removed the defects, sir? There are 2 defects.
My lord.
You remove the defects, list after removal of defects.
Weekly list item 16. Weekly list item number 16.
None appears dismissed for non-prosecution.
Weekly list item number 17.
May I please, my lord? My lord, this may be treated as a PIL, my lord. This is the only objection.
Tell us what the matter is about.
Yes,
sir.
my lord, in this case, due to non-checking of the vehicle during unlock period, 10 persons were died because the vehicle which was coming from Surat was not having any license, any valid insurance certificate. It was not checked for 1750 kilometers from Surat to Orissa. It was not checked at any point of time. When you are
so where are these persons? Who are they?
They are the Berhampur persons. I am challenging the inaction of the RTO and
no. Who are they made parties here? These affected persons.
My lord, they are. This vehicle was not having any insurance. They are not also.
Sir, some persons are affected for whom you are seeking compensation. Correct? You are seeking compensation for the affected persons.
My lord, that is true, but it is only.
What is true? Then, if it is true, where are they?
Well, they are the poor persons of the village of Berhampur.
Why are they? Are they have names or they don't have names?
They have names, yes, sir.
Why are they not before the court?
It is,
why don't you help people file petitions in the court? Why have you coming forward every time? You say the affected persons ought to have been helped to approach the court.
Yes, 15.
Counsel the petitioner states that he will accordingly withdraw the present petition to enable the actually affected persons to themselves file appropriate petitions and seeks to withdraw the petition. Petition is disposed of as withdrawn in the above terms.
Weekly list item 18.
My pleasure, Lordship. My Lord, the petitioner is before your Lordship because of the imposition of fine by the RTO.
What is the fine amount?
The fine amount is of rupees 30,000 in the column of change of address. He has purchased the vehicle in Gujarat and he is now want to change his address. My Lord, this is a covered matter, my Lord.
No. What is your prayer?
Lord, my
Come to your prayer clause, sir.
Yes, ma'am. It is therefore prayed that this honorable court recess will be pleased to admit the writ petition is notice to the opposite party and after hearing be pleased to issue appropriate writ directing the opposite party to accept the amount of rupees 300.
What is this 300?
Rupees 300 is only for the collection of fees amount for change of address.
I don't understand. What is this? Who's for the?
My Lord, this is a covered matter, my Lord. Matter, my Lord. By this honorable court, there are judgments of this honorable court. Where this honorable court has directed to accept the.
Who's for the other side?
Mr. Behra, I think.
Mr.
RTO.
Yes.
State Transport Advocate, Mr. Prabhakar Behra.
Where is he?
Prabhakar Behra is appearing for transport man.
Yeah, No, we allow this in light of that connected matters.
Yes.
Yes, Lordship is disposing lot of matters.
All right. Disposed of in terms of the judgment. All right.
Obligement.
Weekly list item 19.
Item 19. My Lord, item 19 the matter is relating to 148 notice, and in the meantime, they have filed counter. Will file rejoinder, my Lord.
Let it become on 7th.
7th. All right.
Weekly list item 20.
My Lord, item 20 are appearing without issue of applying with 148A. So income tax matter, my Lord.
All right.
Without complying with
7th
148A.
March. All right. 7th March.
7th March, my Lord.
Weekly list item 21.
21, my Lord. The present petitioner, being a Sarpanch of the Kharang Panchayat, has filed a representation before the collector Bhadrak regarding irregularity in distribution of allotment of Pradhan Mantri Awas Yojana. That is pending before the collector Bhadrak.
We made the affected parties.
No.
But we have not implemented the affected parties, sir. You have to implement the affected parties.
Because I am a Sarpanch. I am the Sarpanch of the Kharang Panchayat. I have filed
You
this
know, whoever has got
application.
who has got illegal benefit of the Yojana, you must make them parties. All right.
Lordship had asked them to remove the defects. He has not removed the defects.
No, anyway. Counsel the petitioner seeks leave to withdraw this petition with liberty to file a proper petition, including all necessary affected parties in the petition. Dismiss is withdrawn with liberty.
Weekly list item 22.
I may please the Lordship. This is merely disposal of Annexure 3, page 15. That the allegation against one of the associated professor of opposite partner 4, who was appointed without being qualification, experience, other things. Inquiry was also conducted at page 32.
Is there a proof of you have made this to some particular IAS officer?
No, I have.
Where is the proof of delivery of this to her?
No, I have not made any IS officer as a party here.
Not party. Come to page 15. The representation you have given to the Secretary Department of Empowerment.
Yes, ma'am.
Where is that receipt? Where is the receipt of this?
That receipt I don't have in the
So you make a fresh one and show us the proof of receipt of this. You say counsel the petitioner seeks leave to withdraw this petition with liberty to make a fresh representation to opposite party number 1, and after following up on such a representation to file appropriate proceedings in accordance with law. Disposed of is withdrawn with liberty.
May I pray that if I will file a fresh representation,
Yes, yes.
let the authority consider it the same within a stipulated period that can be
If
done.
such representation is made not later than 21st March 2022, it should be considered and an appropriate order will be passed after hearing all affected parties. Not later than 2nd May 2022.
Obliged.
The court clarifies it does not express any view on the matter.
Lordship has not intended to make.
May I pray, my lord, this appearance we have noted, but this person who is not affected in any way is filing one after another allegation against them.
All right.
Quick list item 23.
My lord, I pray your lordship may kindly see the condition of the annexure 12, the condition of the tree, roadside tree.
So there are defects, you remove the defects, sir. List after removal of defects.
Quick list for admission item 24.
My lord, may I pray that the apprehend anything may happen because
So you remove the defect will immediately, say list immediately after removal of defects. All right.
if it comes then 7th or 8th.
You remove it, sir. If you remove it before, it will come even before. All right.
For admission, we list item 24.
None appears dismissed for non-possible.
We are for the opposite party, my lord.
I am for the opposite party too, my lord.
All right, sir. All right.
We list item 25.
25, my lord. I am for the petitioner. I am challenging the order of the insurance ombudsman, my lord.
We'll take it and enter the board, sir.
We list item number
Lord,
26.
I pray for some other day because I have some difficulties, my lord, today. Sir.
All right. In item 25, the request to counsel the petitioner list on 16th May.
We list item 26.
None appears dismissed for non-possible.
We list item number 27.
None appears dismissed for non-possible.
We list item number 28.
May I please your lordship, my lord?
Yes.
Here it is a PIL filed by the my lord, villagers of different 7 Gram Panchayat of Suguda village, my lord, where they are living in a difficult area where their children are unable to, my lord, prosecute higher education,
We'll take it on some other day, sir.
My
lord. On 10th May.
My lord, my lord, can it be little earlier? Because, my lord,
So this we listed on our own. You did not mention it for listing.
My lord.
Copy of the same may be served on.
We list item 29.
None appears dismissed for non-possible.
And for the opposite 29 adjourn next week.
We list item number 30.
Adjourn next week. Adjourn next week.
No, we're not adjourning matters like this. Yes.
I'm for the opposite party, my lord. My name may be recorded.
All right.
We list item 30.
Item 30 is a matter has become infructuous.
Counsel the petitioners states that it's infructuous. All right.
We list item 31.
May it please your lordship, my lord. My lord, it is a PIL ballot. My lord, in fact, to notify Salepur Panchayat Samiti as a NAC ballot, but there has been a proclamation by the governor of Orissa twice, ballot, and there has been compliance of all the formalities. And lordship will kindly see at the last of the authorities wanted ballot to resubmit ballot the proposal. The proposal was also resubmitted. Lordship will kindly see page
We'll take
87.
it on another day, sir. All right. List on 16th May.
When I say one sentence for that, yet they state in the counter, they have admitted that yes, everything has been done, but they have to simply comply.
All right.
We list item 32.
32. May it please your lordship. My lords, sir. Am I audible?
Yes.
My lords. My lords, sir, this is a PIL for the upgradation of the school for deaf. My lords, the specific allegation is that even after Right to Education Act was implemented and there has been recommendation by the state government for upgrading the school to high school, my lords, And this is the only school
We'll
for
take it up in an early date, sir. I think this is important. You say list on 23rd March. All right.
all right.
Weekly list item 33.
My lords, I am 33, my lords. I beg your lordship's kind permission to post it to some other day, my lords, where the petitioners are the government advocates of a district challenging a notice of the collector asking for deposit of TDS of last 4 financial years, my lords. My lords, there is an interim order, my lords. Lordship may kindly fix any date, my lords. I'll be obliged.
All right. 28th June, 20 June.
Interim order to cut.
Yeah, interim
Weekly
order.
list item number 34.
Item number 34, the affected farmers have filed this PIL because the water reservoir was damaged due to other project. The government implemented a project for road and bridge.
List on
near
12th
the-
April. We'll take it on 12th April.
12th April. Weekly list item 35.
My lords, item number 35, my lords, the file has been misplaced.
Pass over.
Weekly list item 36.
Your Lordship, item 36, Your Lordships. In this matter, the pleadings are completed, Your Lordships. Lordship, the positive time, it will not be possible to hear this matter today.
All right. List on 21st June.
Obliged, Your Lordship.
Weekly list item 37.
My lord, appearing for 37, Your Lordship. My lord, in this case, after the death of the HSE, the entire proceeding is initiated. Notices were issued after his death.
Or we'll list it on 22nd April. 22nd April. All right.
Weekly list item 38.
38, my lords, I received counter of filing rejoinder in course of the day, my lords.
And
One thing I have to clarify, in the second case, I am there. They have not filed a counter in the second case, man.
All right. List on 27th June. In the meanwhile, pleadings be completed.
Weekly list item 39.
And my lord, I am for the petitioner. It's an application seeking for a direction to fill up the post of the members and presidents of different.
Affidavit you will file by next week, my lord. By within 2 weeks. Draft is ready.
All right. Mr. Paddy says that the counter affidavit draft is ready and will be filed within 2 weeks.
Okay, number 3.
Joined up for the next date. List on 5th May.
Weekly list item 40.
Item 40.
That commercial matter.
Two matters were at the last. That is the 5491 and 5494.
So today I don't think we'll be able to take up this.
Those two matters are new on the board. So the usual
The same interim order can,
All right.
same interim
Yeah,
order.
549194. You say the proceedings may go on, but no final order shall be passed.
May I submit, my lord, in item
Interim orders to continue in all matters. We'll have it on 12th May, sir.
My lords, may I submit, my lords?
Can I pray for an earlier date, my lords?
My lords, item 40, my lords, may I submit, my lords, here that court is almost it's almost at standstill because of these developments. In every other case, these jurisdiction is being challenged. So this needs to be resolved quickly, my lords.
All right.
All
7th
commercial matters are blocked.
All right, 16th March then. All right.
May I please, my lord? May I please, my lord?
Just
My
make a
lord,
note of 16th March. This is a large batch.
May I pardon my lord? I pass over item old matter.
Where is the other side?
My lord, I have already called. Other side is.
Yes, sir. He says it's covered.
Yes, madam. Yes, my lord.
It is covered.
It is covered.
All right. Then we say allowed in terms of the judgment. We'll pass the detailed order.
19.
may I please, my lord, item number 7, I may be pardoned. At the time it was called up, I was in other court. I could not attend.
All right. You just say subsequently, Mr.
Item number 1.
Mohanty appeared. The order is recalled. List on. 26th April.
Matter which I mentioned early morning, my lord.
the matter which I mentioned, WPCL.
Passovers will have to give dates only. All right.
Pardon?
Which was your matter, sir?
Sir, item number 1, what I am praying,
yes,
let it come along with read appeal number 446 of 2013. This is a corrected matter. That is my suggestion.
Item 1.
Item number 1.
Read appeal number?
Read appeal number 446 of 2013.
Is this Dr. Prabhavati Kar's matter?
My lord. My lord.
What have we passed? This was a non-prosecution. You say subsequently Mr. Kar mentioned the matter. The order dated, the above order is recalled, list along with writ appeal number so and so
2016
on 21st March.
I may make mention, my lord.
But in the first hour, the matter which I mentioned, my lord, WPCRL. The matter which I mentioned in the first hour, my lord.
So the court master will give the dates in all the past over matters, sir. We have a reference at 2 o'clock.
My lord, WPCRL, my lord, which I mentioned in the first hour, my lord. To take up that matter, that person has been trapped.
DR will place the record before us, sir.
I'm sorry, my lord, item 44 of the special list, my lord.
Sir, all the passed over matters, the
Not passed
master will give dates.
What may I submit, my lords? I'm not audible. Your lordship passed what order? No, my lords. I'm
The
not.
court master will tell you, sir.
My lord, item number 7.
Oblige, man.